rise if able.
Yes.
My lords.
We're going in this order now, are we? So we're jumping to 5, are we, at this stage?
Unless your lordship wishes.
Not at all. No, you're the best judges of how to present. Just to say that we've had some opportunity to look at the min subs, which you kindly provided us with before. Thank you very much for that. I mean, there are plenty of things in the bundle that I wonder why they're there, but that's not one of them. It seems to be quite central to the issues that we're considering. Yes. Now, Miss Williams, we're on Commonwealth, are we now?
Yes, my lords. Turning to issue 4 then, the Secretary of State's primary position, for reasons that I will explain, is that the power to issue an exclusion direction in relation to a Commonwealth citizen derives from the statutory powers, in particular Schedule 2 of the Immigration Act 1971 and Article 13.
Sorry, we're just writing. It's statutory by virtue of.
Schedule 2 of the Immigration Act,
Yep.
1971, and Article 13 of the 2000 order. I intend to structure my submissions on this point as follows. So firstly, I'm going to address you briefly on what an exclusion direction is. Secondly, address you on the Supreme Court decision in Munir, which considered the general impact of the passing of the Immigration Act 1971 and the effect on any existing prerogative powers to exclude. Thirdly, address you on why G1 is not binding authority, to the contrary of the Secretary of State's position. Fourth, then turn to address the question of where in the statutory powers you find the source of the power to exclude, with reference briefly to case law authorities supporting that position, the case of Kakani. And then finally, to just address the authority of New London College, which isn't in the authorities bundle, but was handed up yesterday.
Got it yesterday, Luz.
Yes.
And the point when I come to that is that if you're not, it's a secondary position. So if you're not with me on the primary position, then it's put forward the secondary position in terms of the incidental and ancillary powers.
So, incidental or ancillary?
Yes, my lord. If I turn then to the first issue, so what is an exclusion direction? Conscious the court has already been addressed on this, but to just briefly reiterate, there is a distinction between an exclusion direction and an exclusion order.
Say that again, I missed that.
There's a distinction between an exclusion direction and an exclusion order. An exclusion direction is made on the grounds that it is conducive to the public good and is made by the Secretary of State. And there are separate provisions in various regulations.
By the Secretary of State personally?
Yes, my lord. And there are separate provisions in various regulations regarding exclusion orders, but we're not concerned with them in this case because it was an exclusion direction that was made.
Right, but what are the, tell us what an exclusion order is, what, and under what?
So there's reference to it if it helps. It's in the additional authorities bundle from the Appellant, actually, in the exclusion from the UK guidance.
But before we get to the guidance, I normally look at the statute. If I'm talking about an exclusion order, I need to know who's got the power, what criteria, and what's the effect of. There's no statute dealing with something called an exclusion direction, is there?
I can't take you to a statute which sets out provision for an exclusion direction. What I was going to do is take you to the powers which take the exclusion direction into effect and where they are found. But what I can't do is take you to a statute which says this is when the Secretary of State will make an exclusion direction.
My question was a different one, which
Yes,
is just
no.
I understand an exclusion order is something completely different with which we're not concerned, but I'd just like to remind at least myself what it is and why we're not concerned with it.
My Lord, yes, perhaps it's tab 5 of the additional authorities bundle
Thank
from
you.
the appellants. You'll see the guidance on exclusion from the UK.
Right, I'm sorry, is it tab 5 in the main authorities bundle or?
No, it's the additional
Additional-
appellants authorities bundle. And it's page. So actually, I'll let you get that, my Lord, first.
No, I have page 95.
Yes, so it's page 99 in tab 5.
So this is the Home Office guidance.
Yes, and there's the heading just by the first hole punch which says decisions and orders in purple, and then sets out the difference between an exclusion decision and then an exclusion order.
Page 99.
My Lord, yes.
So the student order is therefore a historical thing now because it's made under regs which are no longer in force. Is that right, or is it?
I understand they are still made exclusion orders.
I thought the regs.
Saving-
This is a 2021 guidance.
It's on the following paragraph, is it? Reference to.
Oh, I see. Yes.
Some transitional provisions.
I think I'm being told they're not still made, but they do still exist, exclusion orders. So they
Oh, I
haven't
see
been
what you mean.
revoked if they were made.
Yes.
And there are
As my Lord points out, that there's some sort of transitional provision which is referred to in the next para, opposite the second hole punch. But though that too will have run out, as I understand it. Anyway,
And so turning to the exclusion direction in this case, the exclusion direction is twofold. It's firstly a direction that the individual is to be refused entry clearance to the UK whilst the exclusion direction is extant. And secondly, it's a direction for the cancellation of any leave to remain in the UK.
You switched, I think, to the letter. Is there anything in this document guidance which tells me what an exclusion decision does, or what the legal effect of an exclusion decision, as you call it, is? I can see grounds, for example.
My Lord, I'm being told page 123.
did you say 1, 2, 3?
Yes, my Lord. And I just wanted to flag before moving on to Munir that although of course that was the effect of the exclusion direction in this case, the second limb does not always arise because not everyone who is excluded has leave to remain or leave to enter the UK. So think, for example, of an individual who is in the UK as an overstayer with no valid leave to remain, leaves the UK whilst on bail for an offence. In that case, if the Secretary of State makes an exclusion direction, there's no need to go on to cancel any leave to remain because the individual doesn't have any. So just to make clear that it's not every case that you have both of those limbs. There may be cases where just there's one limb arising as a consequence of the exclusion direction.
And this will sound pedantic, but I just want to make sure that I've understood. You say the first limb is to be refused entry clearance. At a level of theory, they're not being refused entry clearance, they're being refused leave to enter, which will normally, the first step in which will normally be entry clearance. But you could have a case where someone didn't have entry clearance
And arrived at the border.
but appeared at the border, and then you'd refuse them leave to enter. Yeah.
With that definition in mind, if I could then turn to Munir, that's at tab 18 of the authorities bundle.
Sorry, are we leaving this guidance?
Yes, my lord, I was intending to.
There's quite a lot in it. But you might want to, I appreciate you're dealing with a specific issue, but as it's, I don't think we've been taken to this.
I think we were taken to a part of it, weren't we, by
I haven't,
Mr. Butler. We were taken to page 122.
Yes, the section there where a full submission has been made to the Secretary of State.
right, well, I was looking at page 107, which contains comment on level of criminality, followed by other sorts of behaviour that might lead to exclusion.
My lord, I think my learned leader will come back to that issue. I'm not sure it's
Thank you.
entirely relevant to this.
No, it's of course not at all relevant,
Yeah.
but I just want at some stage, as we're leaving it, to put down a reminder that I'd like to return to it at some stage to understand fully what guidance was being applied when we come to issue 3, perhaps. Yes, now you were going on where?
To the authority of Munir, which is at tab 18 of the authorities bundle.
Thank you.
If I may just start with a brief summary of the facts of this case. But before I do that, the Secretary of State's position is that this is binding authority to the effect that the exclusion of Commonwealth citizens is founded on statutory powers. Moving to the facts, just very briefly, the Secretary of State had a deportation policy, which is referred to in the judgment as DP 596, that applied to parents with children with long residence in the UK. And this was a policy that was published outside of the immigration rules. And the question before the Supreme Court on appeal was whether the policy, and a question about a subsequent withdrawal, amounted to a statement as to the practice to be followed, so as to mean that it should have been laid before Parliament pursuant to section 3.2 of the Immigration Rules 1971. And what you can see in the decision is on page 323 of the bundle. Paragraph 22, you see there the primary submission given by the Secretary of State. I just leave you to read paragraph 22. And the reason that's important is because there was a submission from the Home Secretary that the making and laying of the rules before Parliament is an exercise of the prerogative power, such that the source of the power to lay down immigration rules was something the court had to determine itself to see a section 3.2 bits. And so that's why you see the discussion that follows in the subsequent paragraphs about the source of the power to lay down immigration rules. It was something the court had to determine in Munir. And turning to the judgment, Muller's have already been taken to the relevant sections, but it's paragraphs 25 and 26, which start on page 324 of the authorities bundle. And my submission is that the import of these paragraphs is that, firstly, any pre-existing prerogative power to control entry of alien enemies was expressly preserved by section 33(5) of the Immigration Act 1971.
Sorry, can you just make that proper? Any processing, was that the
Sorry,
word?
any pre-existing prerogative power
Yeah.
to control entry of alien enemies was expressly preserved by section 33(5) of the 1971 Act.
So I'm a very slow writer. Pre-existing prerogative power to what?
Control entry of alien enemies.
Alien enemies. Was an exercise of the was
Expressly preserved
expressly preserved. Yeah.
by section 33(5). And that in relation to Commonwealth citizens, the power to control their entry to the UK derives solely from the 1971 Act. And this is my submission is evident from paragraph 25. It says, subject to the express saving in section 33(5), so that's the express saving in terms of aliens, all powers of immigration control were to be exercised pursuant to the statutes. And also, towards the end of paragraph 26, in fact, it's the last sentence of paragraph 26, it says the Act was intended to define the power to control immigration and say how it was to be exercised.
Is there any significance in the fact that he talks about define the power to control immigration and also to be exercised pursuant to the statute? Does that leave open a theoretical position that the powers are still prerogative powers, but how they are to be used is what the 1971 Act provides for? Maybe a distinction without a difference, but I'm not sure. It's such a tricky area.
My Lord, I'm afraid I don't at the moment have an answer to whether prerogative powers could exist concurrently with a statutory provision.
If it had said the prerogative power to do X, Y, and Z shall be exercised only in the following ways, that would be a perfectly sensible thing for Parliament to say, wouldn't it?
Yeah.
Rather than X is granted by Parliament the power to do X and Y. It might not make much difference, but it's such a tricky area. I just wondered whether he expressed it rather carefully for that reason.
I wonder if the answer might be in paragraph 25, where it says Parliament must have considered that the prerogative power to regulate immigration control did not apply to those who owed their allegiance to the Crown as British Commonwealth citizens.
But on the face of it, prerogative is something entirely separate from statute. It's the whole point of it.
Well, the definition of the prerogative historically has been those powers left in the hands of the monarch. And where powers haven't been left in the hand of the monarch, they've been dealt with by statute. then there's certainly an abeyance and possibly a dead parrot forever.
Well, I don't want to get bogged down in a theoretical debate, because at the moment I'm not sure whether if that's what Lord Dyson meant, it makes any difference in practice than simply saying the power was conferred by Parliament. It'll come to the same thing, but so I don't want to. I just flag it up in case it's relevant to anything we have to consider later.
I was also going to take my lords to paragraphs 32 and 33, which are on page 326 of the authorities bundle. Which again supports the proposition that the power in terms of Commonwealth citizens to exclude is now found in statutory powers in my submission.
So which paragraphs do you say?
It's paragraphs 32 and 33. And then
Well, I think that also answers the second
yes.
sentence, third sentence of 33 really answers my question, I think.
Yes, and towards the end of the paragraph, but if contrary to my view, the prerogative power is exercisable in order to control immigration of Commonwealth citizens before the 1971 Act came into force, then the power was implicitly abrogated or at least suspended by the Act.
Yeah, well, I think, sorry to have started the hair running, that seems pretty clear.
So those paragraphs give a clear indication that the Immigration Act 1971 now contains the power to control immigration of Commonwealth citizens in the UK. And what we say is that clearly extends to exclusion. Now, I was going to take you to deal with the questions of who is an alien and whether this was ratio or arbiter, but you've been taken to those already this morning, and so I don't intend to repeat what's already been said. What I wanted to address you on is why I say G1 is not binding authority to the contrary of that proposition. So G1 is found at tab T1 of the authorities bundle. Starts at page 389. I think a short summary of the facts is important to understand G1. So G1 was born in Sudan and gained British citizenship. He then left the UK after being charged with a public order offence. And the Secretary of State made an order under section 42 of the British Nationality Act, depriving him of citizenship on the grounds of the public goods because of his alleged involvement in terrorism activities. And by virtue of the appeal scheme in the British Nationality Act, G1 argued, I should say I'm calling it G1, not GI. I think it is G1, but I could be wrong.
It's printed as GI in the law report.
It is printed as a GI, but I think it may be another T,
wrong.
that it should be G1. So G1 argued that Parliament had extinguished the Crown's prerogative power to exclude a person pending an appeal under section 42 of the Act. And the reason that those facts are important is because, firstly, my submission is that this is not authority for the proposition that the power to exclude generally is a prerogative power. Because the claimant was a national of Sudan, the court was not concerned with the source of the power to exclude a Commonwealth citizen, but instead the source of the power to exclude an alien friend.
So I'm being slow. I thought at the time of the exclusion, he'd lost his nationality.
Yes, my lord.
And the challenge was to the exclusion, not to the deprivation of nationality.
Yes, it was to the exclusion on the basis that the Secretary of State didn't have the prerogative power to carry out that exclusion whilst he had a pending appeal against the deprivation of the citizenship. And the reason why I say that's important and the decision makes this clear is paragraph 11 of the judgment, which is on, forgive me, page 399 of the authorities bundle. You can see it's the second sentence from the end of that paragraph, just above C. It is common ground that by virtue of its prerogative, the Crown has ample power to exclude an alien from the UK unless the power has been abrogated or modified. So it's to exclude an alien from the UK, the statement that was being considered in paragraph 11. And so my submission is that comment is limited to the existence of a prerogative power in respect of an alien. It doesn't address the source of the power to exclude a Commonwealth citizen, and there's no need for it to do so because the case was not concerned with a Commonwealth citizen. Further, the source of the power to exclude was not an issue in the case, and neither party thought about whether the Immigration Act 1971 might provide the source, and nor did the court, it appears from the...
As I understand it, there may also be a distinction between what exclusion is. If it's an alien and the Secretary says, I'm exercising my prerogative power to exclude him, that means that, well, what does it mean? It's not illegal, it's not a breach of the criminal law for the individual to enter the United Kingdom. What it means is he'll be turned back or removed. So even the exclusion under the prerogative isn't actually the thing that causes legal consequences, it's the turning back at the border.
My Lord, yes. And what I say in relation to paragraph 11 then is, insofar as G1 dealt with aliens, it's not binding in relation to Commonwealth citizens, whereas Munir is binding authority for the proposition that exclusion of Commonwealth citizens is founded on a statutory power. I just make two further points, which is that the existence of the prerogative power in respect to the exclusion of an alien was assumed in G1, which is evident from that paragraph that I've already taken my Lord to. And so the decision didn't include any consideration of the history, the origins, or the scope of the prerogative power. Like I said, any consideration of the Immigration Act and whether that had abrogated and replaced any such prerogative power. And it was limited to the discussion about the British Nationality Act. And whether that abrogated the exercise of the assumed prerogative power when an appeal against the deprivation of citizenship was pending.
And the sequence of events was that the two cases of Munir and G1 were taking place at the same time, but without reference to each other. So that in the Supreme Court, Munir was argued in April. In this court, G1 was argued in May. And in this court, judgment was given in G1 in July, and judgment was given in Munir later in July. So they, as it were, weren't joined up in any way.
Well, that was actually my third point, which is that the decision in Munir postdates the decision in G1, so they didn't have the benefit of Munir in G1.
Yeah. All right.
So I say, for those reasons, we're looking at the statutory powers in terms of where we find the power to make an exclusion direction. Turning then very briefly, I'm conscious of time, to where the power is found. My Lords have already been taken to the provisions. I can take you there again.
This is your fourth point. Thank you.
Yes, it is, my
Keeping
Lord.
track, right? So
Yes.
the power is found. You're going to remind us.
So the first point is that there are very broad powers given to the Secretary of State under Sections 1 and Section 3 of the Immigration Act 1971 to control and regulate immigration in the UK. I don't think we need to turn to those. But if we turn then to paragraph 1.3 of Schedule 2 to the Act, which is in tab 1 at page 37 of the Authorities Bundle.
Page again?
It's page 37. It's subsection 3. You'll see in the exercise of their functions under this Act, immigration officers shall act in accordance with such instructions, not inconsistent with the immigration rules, as may be given them by the Secretary of State. And so the Secretary of State has powers to give instructions to their immigration officers to refuse any future application for leave to enter the UK. And as to the condition that it's not inconsistent with the immigration rules, any instruction is not so inconsistent, because what we see is that paragraphs 9.2.1 and 9.2.2 of the immigration rules reflect this power. And then there's the second place where you see the power, in this case I should emphasise, is Article 13.7 of the 2000 order, which is found on page 52 of the authorities bundle.
Oh, it's a different 2000 order. We were given a 2000 order.
It is the same order, I believe.
We just got it
My
twice.
lord. It might be easier to have a look at it in the...
It is.
And what you'll see there is Article 13.7 at the bottom of the page gives the Secretary of State the express power to cancel an individual's leave to remain in the UK where that person is outside the UK.
Why didn't the Secretary of State send the letter herself to the appellant cancelling his leave to remain then? She didn't have to instruct somebody to do it.
She's not obliged to send it herself. You can see from that provision.
Maybe cancelled.
She can carry out that function through her officers.
Well, in the case of leave to remain by the Secretary of State, why have they got the contrast between, why is the immigration officer and the Secretary of State? If, for one, leave to enter and leave to remain somebody else.
Article 13 does various places distinguish between an immigration officer or the Secretary of State.
My lord, yes. So I'm being told it goes back to section 4 of the Immigration Act. Thank you, page 21. The first section there, you'll see give or refuse leave to enter the UK shall be exercised by immigration officers, and the power to give leave to remain in the UK or vary any leave shall be exercised by the Secretary of State. So there's a distinction between the functions that the two can carry out.
But to spell out the obvious, the Secretary of State option is not the Secretary of State personally.
No.
It's the Secretary of State subject to Cartona. Yeah.
My lord, I think we covered that earlier.
I'm
as
sure
well.
that's obvious, but I just, since we've had a problem about Cartona earlier.
Yes.
And so my submission is that those express powers found in the Immigration Act give the Secretary of State the power to make an exclusion direction, because that is the effect of an exclusion direction for the reasons that I already explained at the outset of my submissions. Just turning then, I don't know how swiftly my lords would like me to deal with this authority. It's an authority of Kakani, which is in the bundle, tab 22.
This is the,
It's just a similar.
It is, yes.
it wasn't.
Yeah, so it's a decision of Mrs. just as similar as she then was.
Well, I think
It
actually then
even-
wasn't.
Yes, sorry.
He wasn't even that. What a meteoric rise.
Right.
And it concerned an Albanian citizen who is a non-Commonwealth citizen. I think the point about this authority is that it supports the position that the power is to be found in the Immigration Act. The power to issue an exclusion direction is to be found in the Immigration Act. I can take my lords through
Right.
the...
Did you say this is a non-Commonwealth citizen?
Albanian.
Yes,
Albanian, thank you,
an
yes.
Albanian.
Yes. Okay.
It might be helpful to pick up the judgment from page 420. And the heading at the bottom of the page there, the Alvey ground, you'll see there's a summary there, paragraph 44, which just sets out the context within which this discussion arose. So this involved a decision under paragraph 326 of the rules, which at the time provided that entry clearance is to be refused where the Secretary of State personally directed exclusion of a person is conducive to the public good. Now, this paragraph no longer exists, but is set out in paragraph 9.2.1 of the rules, which I've already referred to.
It's equivalent.
Yes, my lord. And you see the argument that's being made at paragraph 45.
If you think about it, not so much as an exclusion direction or an exclusion decision, it's a decision to cause others to bring about a state of affairs where you won't get in or out. What's been bothering me is it sounds as if the thing, the direction, has an effect, but it doesn't. It's an instruction to others to bring about an effect. Also use of it, yes.
And you see the argument set out in paragraph 45 rejected in paragraphs 46 and 47. And what those paragraphs find is that the source of the power to exclude is not through the immigration rules, although the immigration rules do assume the existence of such a power. This was the finding in this case. So the same can therefore be said of 9.2.1.
So sorry, where are you reading from now?
Forgive me, so it's paragraph 46 onwards.
Yes, I see.
Paragraph 46, paragraph 326 of the immigration
Yep,
rules.
thank
So
you.
it assumes the power, but decision is that is not the source. And then it goes on, paragraph 47, to focus on various provisions in the 1971 Act, including the broad powers that I've already referred to under sections 1 and 3. And then concludes in paragraph 47 that the provisions in the 1971 Act are amply wide enough to confer the necessary power on the Secretary of State to make an exclusion decision in respect of a foreign national who is outside the UK.
And paragraph 54 is helpful because that says what the effect of that exercise of power does.
My lord, yes, and that's why the facts of this case are important, because this was an individual who didn't have ILR, so we only focus in this paragraph on paragraph 326. There was no need to go on to consider the power to cancel ILR, but I've already taken the court to that power. Now, of course, whilst this decision supports the general proposition, what it doesn't deal with is the question that has arisen, which is when there's a reference to immigration officers in the 1971 Act, does that extend to ECOs? Because that wasn't a point that was raised in this case. Now, I rely on the submissions that you've already heard from my learned leader on that point. But in short, my submission is that when one looks at the history in terms of what the position was when the Immigration Act 1971 was brought into force. In particular, there's no reference to entry clearance officer in the 1971 Act, and that's because when the Act was enacted, entry clearance did not have the effect of giving someone leave to enter. And I don't want to go over ground we've already covered in terms of the submissions that have already been made.
I mean, it's put in different ways. Implied power was what was Dunlop said this morning. I'm just wondering whether the reference to immigration officers could be seen as shorthand immigration officers brackets, i.e. those people, whatever you call them, who exercise the powers conferred upon immigration officers, or whose decisions have like effect. I don't know whether you can do that. But the words in an act have got to be made to mean something in out of fashion. So it's implied power or interpretation of the word immigration officer.
Yes. And of course, what we know is that after the 1999 Act and the 2000 Order, what we see is the terms entry clearance officer and immigration officer could be interchanged in certain respects.
But you've got to get it into the 1971 Act. The order can't do it.
Yes, I appreciate that point, but looking through the history, so at the time when the Immigration Act 1971 was enacted, entry clearance didn't have the effect of giving someone leave to enter. So you still have to get to the immigration officer at the border for them to make a decision on whether to grant leave to enter. We then see the development of the entry clearance role after that, and when the entry clearance officer is carrying out decisions, what they are doing is basically they're sitting in the shoes of what were immigration officers in the 1971 Act. It's an extension of the powers in the 1971 Act by virtue of the introduction of the premise of entry clearance and entry clearance officers. And so my submission is that it's necessary in terms of the exercise of the power of the Secretary of State to give instructions in terms of leave to enter and to refuse leave to enter to a person, that must extend to entry clearance officers acting in the shoes of immigration officers.
And if it doesn't matter because you just cancel it anyway. Will be the logical legal consequence, because you can do that.
My Lord, turning then to just deal with, going to turn to my final point. I don't know if you want to hear submissions on NA Iraq. No. I'll turn then to my final point, which is, if you're not with me on issue 4 and the interpretation of immigration officers in the 1971 Act, then our alternative position is that insofar as there isn't an express power to give ECOs in addition to IO's directions from those two provisions that I've taken you to, that power is ancillary and incidental to the powers that the Secretary of State has. And this is where the New London College Authority comes in. And just dealing with it very briefly, this was a sponsor license case, which involved a challenge that the criteria for eligibility for sponsor license was contained in guidance which had not been laid before Parliament, as was required by Section 3.2 of the Immigration Act, and was therefore unlawful. Familiar argument it may seem. And the court rejected this argument, and the relevant findings are in paragraph 28. Towards the bottom of the paragraph, going on to the next page, sentence that starts with but the question does not need to be resolved on these appeals. It is the statutory power of the Secretary of State to administer the system of immigration control must necessarily extend to a range of ancillary and incidental administrative powers not expressly set out in the Act, including the vetting of sponsors. And then the court continues in paragraph 29 to apply that to the facts of this case and confirm the power extended to the power to establish and operate a system for licensing educational institutions under Tier 4 of the points-based system. And so my submission is that if the power of the Secretary of State to give directions to ECOs in addition to immigration officers is reasonably incidental to the powers that I've already taken you to in the 1971 Act and the 2000 Order. Unless I can assist further, those are my submissions.
No, thank you very much, Ms. Williams.
I'll then, if I may, try to sweep up the issues that I asked for a little bit more time to consider. So the first of those is the procedural element of Article 8. And the procedural element of Article 8 is this, that although Article 8 contains no explicit procedural requirements, the decision-making process must be fair and such as to afford due respect to the interests safeguarded by Article 8. And that's what you get if you read the Strasbourg summary of Article 8 case law. It's what set out in Q&R against Slovenia 19938/20, paragraph 96. I don't anticipate it's in dispute. So, in other words, if you're making a decision, you must have, it must be fair and such as to afford due respect to the interest. Now, in my submission, the ATC refusal, and that is the target here of the Article 8 challenge, the ATC refusal was fair for the purposes of Article 8, just in the same way as it was fair for the purposes of the common law. So for precisely the reasons that Mr. Justice Kavanagh refused permission on the common law procedural fairness challenge, so any Article 8 procedural challenge should also be rejected. That's what I have to say on that point. And then the other point is issue 3 and what was ground 3A. And my short point is that the points raised by my Lord Justice Lewis are not open to this court. They're not part of the case before this court. The issue which we're calling issue 3 now, which used to be ground 3A, is and always has been.
That was historic unfairness.
Yes,
correct?
it's always been predicated on the assumption that the appellant succeeds on issues 1 and 2. It's never been about. I'll just pause.
Never been about.
It's never been about things that happened after the authorities carry refusal, the aftermath, or any other objection to the exclusion decision. It's always been, if we win on these points, then
that upsets the.
Yes, that's what it's always been. And can I just take you to the way it's been pleaded below and above? So I start at page. It's a core bundle. If you could pick up that.
Sorry, just you're always predicated on the appellant succeeding on issues. You put to issues on or grounds. What grounds?
They were round 2 and 4, I believe.
And that's what, but that's now issues
1 and 2.
Yes, I see. Yep.
So if I start back over the statement of facts and grounds, that's in page 248 of the authority bundle.
Of which bundle?
Core bundle, sorry. If you look at, it starts on page 247. By the time we get to these draft amended statements of facts and grounds, ground 3 has been dropped, and we have grounds 1, 2, and 4. And grounds 1 is not pursued before you. So, and ground 2 is what we've called issue 1. It's this submission that paragraph 14F doesn't apply to this claimant. Ground 4 is what's become issue 2 with you. And I note substantive breach of Article 8 ECHR rights.
Hang on, sorry.
Right, it does actually, to be fair, it does say because it denies him access.
Yes, yes. That is absolutely, and that's put in as in terms of being a substantive breach rather than procedural obligation, which is to do with it not being fair. So, anyway, ground 3A was the point I was coming to. Failure to take into account historical injustice. And then the first word is if. If the claimant's grounds 1, 2, and or 4 succeed, it will follow that the refusal of ATC was unlawful. Therefore, the claimant has suffered historical injustice. So it's predicated on if we win on one of these grounds, then we should also win on this one. And that's made even clearer if you go to page 264, paragraph 43A. And again, the same two steps in the logic. If we succeed on one of these grounds, then the authority to carry was vitiated by public error, and this amounts to historical injustice. And so that's how it was pleaded in the court below, and then can I take you now to how it's pleaded in this court? Turn to page 16.
Just one date question. When was the amended grounds amended, or when were the grounds amended?
I don't know that off the top of my head, I apologise. Should, I hope so, at the end of it. 25th of June 2025, it seems. 268.
Mm. 26 June.
25th of June 2025, it says on 268.
The reason I was asking, just in case you wonder, the statement from Mr. Hilton with the exclusion material, the ministerial submission, came after that, but there was no attempt to amend afterwards then.
Not as far as I'm aware, no.
The date of the hearing was, oh yeah, January, there was another 3 months. I know the hearing dates.
But just so that I'm clear about this, we haven't seen the pleadings in the FTT case, but the substantive Article 8 grounds are being run in the about the exclusion order.
Exclusion decision.
Are being run in the FTT. Obviously, that's what they're mostly. That's what that.
I haven't seen the pleadings.
What else can the case be?
Yeah, that must be. That is exactly what it's about. As I say.
Yes, may or may not have a procedural angle as well, but we don't know. We haven't seen the pleading, and we don't know when the substantive hearing is going to be, do we?
I think the chronology mentions there's a case management hearing coming up.
Yes, I see. Because I think you told us.
I thought you said it was August, but I may be misremembering.
August, is that hearing or case management? Case management hearing in August.
Do you think it was deliberately in the hope of having a decision from us in the meantime?
Yes, apparently.
Although logically it might be that was unnecessary because it doesn't matter. Yes, that is the thinking.
Yeah, I think so. Yes.
I'm just looking at the amendment that was made. That was made a couple of weeks after the decision about exclusion. So,
yes.
11th of June, 25th of June.
Yes. Just
in the sequence of things.
Yes. Can I now take it to the grounds which are before you? there's actually two appellant's notice and grounds of appeal because of the procedural history. So if I take you to the one on page 16, I invite you to read paragraph 11. That's the ground. Then I'll take you to the skeleton argument in a moment.
With paragraph 11, did you
Paragraph
say?
11 on page 16.
Yes.
So this ground brought to this court is predicated on Mrs. Justice Farby having made an error in deciding whether the ATC decision was lawful. And then if you go to the skeleton argument, that's very much in line with the ground. So if you turn please to page 34 of the same core bundle. It's put
Sorry, which page?
page 34. Paragraph 3.3 is put very clearly and succinctly. Issue 3, JR ground 3A, if the ATC decision was unlawful, did that vitiate the exclusion decision? It's not wider than that. It's not the exclusion decision was unlawful for other reasons. And if you go to paragraph 42, it's made crystal clear in the first sentence of paragraph 42 on page 43. Issue 3 is contingent on the appellant succeeding on issues 1 or 2.
Sorry, I've got the wrong page.
Page 43 of the
Oh,
core
43.
bundle.
I'm so sorry, I was on 42.
Sorry, it's because maybe the paragraph number is 42. Page number is 43, paragraph number 42.
Yep, thank
Issue
you.
3 is
Yep,
contingent
yep.
on the appellant succeeding
Yep.
on issues 1 or 2. So it follows that that's the only issue before this court, and it's not before the court whether there was perhaps some other public law error in the exclusion decision. And that's why the parties didn't put the ministerial submission in the bundles before you. And that's why I haven't taken you to the guidance and tried to explain why the ministerial submission was consistent with that guidance, because that's just simply not one of the issues in this.
So the only exclusion decision challenge is Varies, based on being a Commonwealth citizen.
Well, there's two. There's one, the sort of historical injustice, if we succeed on issues 1 or 2 point, and then there's the Varies point.
Yes.
Yes, that's it. My lords, that's all I had.
Right. So your position is that, interesting though it might be, the guidance and the ministerial submission, and to the extent to which they are consistent with each other and so forth, fall neither within our appeal nor within the FTT's remit.
I don't know
Or
about
possibly,
the FTT.
possibly within the latter, but not
Certainly
within.
not within what's before you.
I think accurately, the human rights claim, if there is one, before the FTT, may cover much of the ground that was already dealt with in the ministerial submission.
Absolutely,
That's
yes.
the way I think it's accurately framed.
And as I said, I haven't seen the way it's pleaded in the FTT, but I imagine there'll be arguments to say this is not consistent.
What, in one side of the scales this and the other side of the scales that?
Yes, and one point that might be made, if there are some inconsistency with the guidance, that might be drawn attention to as part of the Article 8 argument.
And just a minute, you did say that if the FTT thought they needed to hear oral evidence from Mr. Tasib, he can obviously bring the appeal. Obviously his wife, who thankfully is here now with her child, can go and give evidence, and his family can. The only person, and he can give written statements. What he can't at the moment do is give oral evidence. And you did tell us that the tribunal could want to say, we think we need to hear from him and adjourn and see if
Yes.
Secretary would give limited leave for him to come back for that purposes
Yes.
only.
And,
Yes.
and
Sorry, just to be clear, he can even give oral evidence for abroad, provided that's not a breach of Pakistan, provided the Pakistani government consents.
in theory, that could happen. I think in practice, the Pakistani government hasn't consented, and I seem to remember some evidence that they just don't reply when you ask them.
Well, there's a request for further information. I think there were 5 occasions when Pakistan was asked, and I don't think they even replied, even unrefused. They just didn't answer.
The FTT, I think, issues guidance, doesn't it, now, which countries object and which don't. And which
Guidance
haven't
might have changed.
stated their position.
Yes. So can I just take you just to make good the point that I made about what the tribunal can do? This was discussed in the case of QR Pakistan. Can you turn, please, behind tab 30 of the authorities bundle, page 625. One of those cases, sort of post Piori and Bindlos, where it turns out that the removal had been unlawful, and what should we do about it? Should we grant interim relief, bring them back? And Lord Justice Hickenbottom, I think it was, sets out the sort of facts relevant to deciding whether to grant interim relief, and a factor weighing heavily against it was the fact that the First Tier Tribunal could look at this. And can I just invite you to read page 625, Roman numeral 14.
Yeah.
Thank you both very much.
Thank you very much, Mal.
Thank you, my lord. Could I begin, please, with issue 1? Category 2 of paragraph F. What's the process? My learned friend emphasised the words process. Well, the process is of making a deportation order, in my submission. And you can't make a deportation order in an automatic case until you've made a decision on section 33. So that's our position on category 2. Now, the perhaps best point that's been raised against our interpretation of category 2 is that category diminished to almost vanishing point by our interpretation? Now, in answer to that, could I ask the court please to turn up the guidance again? This is at Authority tab 12. And the court will recall that this is the version of the conducive deportation guidance that was in force when Parliament made the 2023 scheme, and in my submission indicates what it would have understood of the process. If we could look please at page 165.
So sorry, I'm fractionally behind.
It's volume 1, tab 12, please.
Thank you.
Page 165. Now, we touched on this in my opening submissions. The heading at the top of the page, obtaining a deportation order. The second paragraph is dealing with automatic cases. Under the 2007 Act, a deportation order can be obtained following a Stage 2 decision. Now, that suggests that there is some further step after the making of the Stage 2 decision in order to obtain the actual signed piece of paper. What then is that process? I'm afraid a little bit of a paper chase through this guidance document. Could we look next, please, at page 117? Top of that page, this is the opening sections of the guidance. There's a heading Contacts, which reads, if you have any questions about the guidance and your line manager or senior caseworker can't help you, or you think that the guidance has factual errors, then email the Migrant Criminality Policy team. Now, what that is indicating in my submission is that the guidance is talking to caseworkers. That is the you. And then above the caseworker, one has a line manager or senior caseworker. So all I'm indicating here is what's the you in the guidance. The next passage, please, is at page 161. The heading at the bottom of the page, Stage 2 decision to make a deportation order. If no representations are received within the 20 working day deadline given in the Stage 1 decision, you must consider whether to make a deportation order on the facts before you. So that's you, the caseworker, makes that decision. And then one can see that it's the caseworker that's being referred to. If one looks halfway down that page, this is all within the Stage 2 section of the guidance. There is a paragraph beginning further details, which reads, further details about considering an Article 3 medical claim is provided in the Article 3 medical claims guidance. If you need more guidance, you must refer the case to a senior caseworker. So again, that indicates that the you who is deciding whether to make a deportation order is an ordinary caseworker. And to the same effect, on page 162, there is a heading, Cases Involving Children. So medical cases may be sensitive, cases involving children may be sensitive. And then just below the second hole punch, although every family situation is different, there are some principles which can be applied to most deportation cases. Where you have a complex case, or where you feel a more in-depth consideration is required, you can seek further advice from senior caseworkers, who will firstly decide if contacting the Office of the Children's Champion is appropriate. So again, one can see that the Stage 2 decision to make a deportation order is being taken by an ordinary caseworker in a run-of-the-mill case. Right, so that is the decision to make a deportation order. Then who signs the deportation order? And one sees that at page 168. And on 168, there's a heading at the bottom of the page, serving on file process. Now, this is dealing with a situation where you don't know where the individual is, and so you can't serve it, so the Home Office does what's called serving on file. Not concerned with that process in particular, but if one looks at the second paragraph below that, when you have conducted sufficient checks to try and establish the person's whereabouts and these have failed to locate them, is to obtain the agreement of the local team leader or senior caseworker for your initial and subsequent stage deportation proposals, brackets, deportation orders must be signed at director level, close brackets, to be served on file. Now, we understand that to mean that deportation orders aren't signed by ordinary caseworkers, they are signed off by director level people. And that, in my submission, explains why there may not be, there may be a temporal gap between the taking of the making of the stage 2 deportation decision.
Well,
and
does
the
that
making-
work?
and the
Because the
making of the
effective
order.
decision is the one taken by the director level person.
That's the deportation order. So if one thinks back to the
Sorry, I may have
paragraph,
misunderstood.
one thinks back to paragraph 14 categories. Category 1, there's a deportation order. So that's the thing signed by the person at director level. Category 2, on our case,
Yes,
is
I
that
see.
the Home Office is in the process of making the deportation order. And the argument that I'm meeting at the moment is that is not that category has real purpose. And the purpose it serves is in covering the period between the making of the stage 2 decision and the issuing of the order. And the point I'm making is there may be a real gap there, not just a theoretical gap. And so this, in my submission, category 2 of paragraph F on our interpretation does have real purpose.
Yes.
Category 3, I understood there to be, if not total common ground on category 3, then a large measure of common ground where the person has left the UK when on notice of deportation action. The Secretary of State is entitled to treat them as abandoning whatever procedural rights they had in that process. That is certainly my position. I understood it also to be the Secretary of State's position. And what in my submission Parliament was authorising in the 2023 version of the scheme was the extension of category F from category 2, as I've interpreted it, to cover the entirety of the deportation process where the person is on notice. So in that way, one can see that the amendment in 2023 had real utility. By contrast, on the Secretary of State's interpretation of category 2 and 3, the addition of category 3 in 2023 served no purpose. It was pointless because on the Secretary of State's case, everyone in category 3 was already covered by category 2.
I thought he said the difference was that you might have abandoned the deportation process for category 3 because they'd just given up and thought that they're never going to find him or pin him down, so they stopped the process, and that's when they still keep the ATC power. But I may have misunderstood. Oh no, that's right.
Well, it may be that the Secretary of State will choose to terminate the deportation process, but I, as my lord put it, rubbed the court's nose in it in my opening submissions, that is not the legal position. Secretary of State's perfectly entitled to proceed with deportation action, and so therefore the position that on the Secretary of State's case is covered by Category 3 was, in my submission, already covered by Category, on the Secretary of State's interpretation, was already covered by Category 2.
But they'd have to go on and make the deportation order, or
Well,
they'd have to
be
intend to.
thinking about it.
They'd have to be thinking about it. They can't, if they say, well, there's just no point anymore, close the file, there wouldn't be a Category 3 and you'd be arguing they're out of Category 2.
No.
No, they're not in the process of making it, they've stopped making it.
No, but the Secretary of State, if encountering this issue at the ATC stage, won't have thought about this yet. Anyway, but my main submission on issue 1 is that Category 3 has real utility, Category 2 has real utility, and Category 3 has real utility. Could I then make submissions which go to all of the issues, or not all of them, it goes to issues 1, 2 and 3 in the case. And this is to explain why fairness is relevant to all of those issues, including issue 1. Now, can I begin by making the submission that there has been substantive unfairness. I'm not at the moment making submissions about the consequences of that unfairness, just to observe there has been substantive unfairness to the appellant. And in my submission, there are 5 strands to that. The first strand is that the appellant wasn't given notice of deportation proceedings that he would have received while he was still in prison, as a consequence of the maladministration of the prison service. The second strand is that the appellant laid his cards on the table when he applied for a biometric permit.
What is that actually? What do they do? Do they allow him to come back, or?
We understand it to be, well, certainly the appellant understood it to be the case, that he needed the permit to get back into the country. Whether that's right as a matter of law, I don't know, but my instructions are that that was his reason for applying for it.
Did he apply for it? I haven't got the dates in my mind. In contemplation of the present journey.
That's what I'm told.
Yes, no, that's it.
And so
No, it was the previous spring. It was
the
18 months before or something.
Yeah.
Yes,
I need to correct what I've just said, my lord. He understood he needed it to travel, but the journey that was being contemplated was not the journey to visit the ill father.
I thought he never travelled until.
No, he didn't. But he applied for the permit in contemplation of a honeymoon.
Yes, I see. Okay.
So it was in contemplation of travel, just not this particular trip.
I think I read that he'd been to Pakistan twice during his entire life.
No, so he may have felt able to go to and from Pakistan in light of his
okay, but it's anyway. And is it? Does it take the form of something that's stuck in your passport, or is it a separate card or a bit of paper?
You may have heard that. I think I understand it's stuck in your passport.
In terms of substantive unfairness, the fact that he thought you had to have it to travel doesn't make it unfair, and it's either A, he did need to have it to travel, or B, he told the Home Office that and they didn't disabuse him of the need.
Right. Well, I can't say that.
So we don't know.
No. But what we do know is that he brought himself to the Home Office's attention, applied for a biometric permit, one of the functions of which is to demonstrate having ILR, and he was granted that permit. It was an opportunity, if the Home Office saw fit, to commence the deportation proceedings, and thereby put him on notice.
Did he have to tell the Home Office that he had a 4-year conviction? Sorry.
Well, it was my understanding that the answer to that's yes, but I think I better check. We'll check that point. Mr. Halim says he doesn't think he did have to submit.
Ah,
I
okay.
suppose that.
So then it's beginning to look a bit less like substantive
Well,
unfairness at the moment.
it's a less forceful point.
Yeah.
It is still a strand of unfairness, whether or not there was disclosure. He brought himself to the attention of the Home Office. It was an opportunity for them to notify him. So, as I said, my point one is this all ought to have happened while in prison, but didn't because of maladministration of the prison service. Well, second strand, the appellant then brought himself to the attention of the Home Office. That's their opportunity to consider matters.
Well, hang on, but if he doesn't tell them about his offending at that stage and doesn't have to, and obviously the prison service never does, it's just neutral, isn't it? If they brought himself to the attention, it doesn't bring relevant facts to the attention.
My learned junior, I think, is wrong about this. If we look, please, at page 84 of the core bundle. Page 20, paragraph 23. Mrs. Justice Farby makes a finding of fact based on the Home Office records that the Secretary of State was unaware that the claimant had accrued criminal convictions until he applied for a replacement biometric permit.
Yeah, that's what I thought. That's how they suddenly knew he was a criminal.
Exactly. So it does appear to have been a disclosure by the appellant, and that's the Home Office's opportunity to say, well, thanks for drawing yourself to our attention, we now put you on notice that we are commencing deportation proceedings. So that, in my submission, is the second strand of unfairness. Mm-hmm. The third strand, then, is that the Secretary of State, through her officials, knew that the appellant hadn't been given fair notice of deportation proceedings before he left, and decided to stop him returning anyway. That's my Lord Justice Lewis's observation. Now, it's of course possible that in some cases that wouldn't be unfair. My Lord's Suffolk murderer example.
I have nothing against Suffolk, but
no. The murderer might not have had fair notice, but there would be an overriding public interest that outweighed the unfairness or the potential unfairness.
Oh, is that the reason? I thought the reason was that if you committed some really heinous offence, you were bound to know you were deportable, whatever paperwork had or hadn't been served. Well, whereas this, serious as it was, more than the 4 years, is not in that category.
No.
And it would be less surprising for him to think, well, clearly they've decided not to do anything about it.
No, quite. I mean, if the appellant had been intimately familiar with the law, he might have formed the view that the Home Office of its own motion had concluded that one of the Section 33 exceptions applied, and they decided not to go ahead with things. But so I understand why my Lord says that.
But that's not the only point.
That's not the only point.
What is the? Just tell me again what the
point. The way I was putting it was that then there will be cases where even if it might prima facie be unfair, substantively unfair, not to have put the individual on notice of deportation proceedings when they left the UK, it wouldn't be unfair to, and that the decision maker was aware of that when making the ATC decision. It wouldn't be unfair for the decision maker to make the ATC decision anyway, because the public interest considerations were just so overwhelming that he's a murderer, he's at risk of causing mayhem on the plane and when he arrives back, that just overrides everything.
The problem that I've got now is I've read the ministerial submission, and I thought the position was the Secretary of State just hadn't addressed her migrant at all, and that was the end of it. And rightly or wrongly, the Secretary of State has got a ministerial submission which covers everything. I know it came on the 15th of October, which looks like the second day of the hearing, but it's not actually the subject matter of this appeal.
No, but at the moment, I'm dealing with something that is a strand of the unfairness that is within the subject matter of the appeal, which is what the Secretary of State's officials knew when they took the ATC decision. They knew that the appellant hadn't been on fair notice, and they decided to proceed anyway. So that's the third strand of unfairness. I now have clear instructions that the appellant did disclose and notify all convictions when applying for a biometric residence permit, but that one can see that in the judgment anyway. Fourth strand, even if the decision-making process, the ATC decision-making process, was too fast-paced for the Secretary of State to be expected to grapple properly with the unfairness of the appellant not having been on notice when making the ATC decision, she had ample opportunity to grapple with that unfairness subsequently, but didn't do so. As the court has seen, the appellant emailed carrier support the same day that he was refused boarding. And perhaps if I just give the reference, supplementary bundle page 41, he says, I wasn't told when I applied for and was given a biometric card in order to use my ILR that I'd be at risk. I'm paraphrasing, but that's what he says.
Yeah, sorry, yes. Let's be clear about this. The biometric permit, one of the advantages is that you can travel.
Yes.
But it's a residence permit, which also enables you authoritatively to establish your status for many other purposes.
Correct.
Employment or access to the NHS, all those things. So the fact that they issued him to one doesn't necessarily mean they were put on notice he was going to travel.
No, I accept that. But it put them on notice that he was somebody who fell within the purview of Section 32.
Yes, well, that I get.
Yeah. It was their second chance, 18 months before to do it, having not had the first chance when the prison officers didn't send the form through.
Exactly so.
Yeah.
So that's the unfairness, my lord. Not that they didn't stop him from travelling and say, well, look, we know you're about to travel, you need to know this. It's rather that he could have expected to have been told that the deportation process had started. So at the moment I'm on the fourth strand, which is if it was not realistic for the decision maker to confront this unfairness when making the ATC decision, what about the days that followed? And the reference I've given, my lords, is page 41 of the supplementary bundle, where the appellant says, in effect, I wasn't told when I applied and when I was given a biometric card that I'd be at risk. So he identifies the unfairness that I'm complaining about now, and which officials had themselves identified, as my lord points out, at the time they made the ATC decision. So that's his representation. What's the answer? 55 minutes later, page 43, the decision stands.
Yes, I did wonder. I pointed out the interval of time. I wondered since. I had to be a bit careful with emails to different time zones.
We've checked.
Sorry?
We've checked the time zone point.
Oh.
And it's 55 minutes.
The problem is, I see all of this, and I was obviously troubled by it yesterday. And I can understand how, in colloquial terms, you might say this is unfair. But there's lots of cases saying substantive unfairness as itself doesn't amount to ground unless it's lawful. And the real problem that I've got is, if at the end of the day, no matter how harshly treated Mr. Tasib was, if there was an exclusion decision, the ATC, and that hasn't been challenged or was lawful, then to a large extent, what happened with the ATC is water under the bridge.
Well, it's been accepted by the Secretary of State that if the ATC decision was flawed, then that undermines the exclusion.
This isn't the ATC decision being flawed. It's the
Post
process
ATC
afterwards giving
fairness.
rise to unfairness.
But the same must follow as a matter of logic. But anyway, can I deal with the consequences of the unfairness in a moment? I just want to finish my strands of unfairness. I'm still on the fourth strand. 55 minutes later, the decision stands. No grappling with the unfairness. And then page 46, he the appellant, writes again, I've got ILR. I've been told I can make representations on the stage 1 decision. The response, page 49, you'll get a response within 10 working days, but there wasn't one. And there was no suggestion, well, there's no unfairness, make your stage 1 representations from out of country. There was just no response.
Right, we will aim to respond.
My submission is implicit there would be a response at some point, even if not quite within 10 working days.
Your call is very important to us.
Yes.
If I understood him correctly, Mr. Dunlop says about those last 2 points, the aftermath points, anything following the actual refusal decision, not within the scope of your challenge. What's the answer to that?
Well, in my submission it is. It all follows on from the ATC decision. It all goes into the Article 8 mix. The only thing that's off limits is anything that's discrete and freestanding from the exclusion decision onwards that isn't consequential to the unlawful, if I'm right that it's unlawful, ATC decision.
Right, so this is not, you would invite us to look at this not as a series of decisions communicated in emails that fade away to nothing, as it were, not as a series of decisions, but as a single decision process.
Yes, I mean, what I'm addressing at the moment, well, the thrust of my 4th point is to head off a suggestion that it's unrealistic or unfair for me to focus on the ATC decision. And I'm responding to that by saying, well, okay, let's look at what follows. Is there any mitigation of the unfairness? In my submission, no,
Well,
there's no mitigation of
I'm
unfairness.
looking at it analytically in a different way, and looking at the decision as being a decision not to let you on that flight and to maintain that position with no realistic prospect of you being able to be heard on it at all.
Well, quite
And that is a, as it were, a portmanteau
Yes.
situation, and that, as I said it earlier on, salami slicing it into individual letters or actions is not a reasonal way of approaching it. Seems to be what
I absolutely agree with respect.
what your case.
I absolutely agree, and I understood my learned friend realistically to accept that one has to consider the reality of the ATC decision, which is, and of course, we're not going to let you fly if you come back next week.
But the problem is, it was
Effectively,
overtaken
an
by
80s.
events.
Sorry.
I'm so sorry, my lord.
The problem is it was overtaken because the ATC is all to do with getting in, and the exclusion event
Keeping out.
is all to do with keeping out.
Well, that's why I accept. That's why I accept that I'm entitled in my submission to rely on the ATC decision post-exclusion decision to the extent that the ATC decision vitiates the exclusion decision. But what I'm not entitled to do is to challenge the exclusion decision on its own terms under Article 8, because that's a matter for the tribunal. My challenge to the exclusion decision is based on the ATC decision, and the ATC process was flawed in some way, and that undermines the exclusion decision, or alternatively, issue 4, you had no power to do it.
Sorry, did you? Something you wanted to.
No, it's rather moved on, but one way of looking at the point that my Lord Justice Peter Jackson made is to say that in practice, a single ATC decision is effectively a continuing decision.
Yes, I agree.
Because it necessarily follows, though not formally, that any time you attempt to get into the UK by air or train or boat, you will be refused.
Yes.
Unless the system slips up.
I think it was, if I don't know which law lord it was, Lord Steyn in the Burkitt case, public law is about substance rather than form. In substance, this is a public law decision that was going to have enduring effect.
Yes, I was looking also, or rather at the fact that it's one thing to have a decision which has to be taken on the spur of the moment, but where there is a responsive system that lies around it, so that you can then put forward your arguments as you do in your 2 emails, to which they can say, well, we've considered that, and for these reasons we don't, we'll continue to oppose. The most that you had from this was came in a sequence that we've carefully reviewed it and the decision stands. That's the first one that you gave us at 43.
Yeah.
And then when you try again, is it 46 which you showed us? There appear to be 2
46 is
two communications. Is one cut and pasted into is the official material at the top of that page cut and pasted into the private email that's then sent?
Yes, I think so. So it's 46 is the second email from the appellant, and then the response to that one's at page 49.
This is plagiarism. My lord said to me outside, it's almost as if, in substance, they're not in form. If you're going to take a decision which, in practice, has to be taken too quickly to get an answer, there's got to be a return date.
Yes. Yes.
Like an ex-party order.
Yes.
It's a nice analogy.
Now, there isn't a return date, and there is a number you can get in touch with, or an email address you can write to.
Yeah.
But then it's not to be taken seriously, like a return
well,
date
absolutely.
is.
I was going to say that if there was a functioning system which had either resulted in if it had resulted in a decision, well, in light of what you've said, we can now see that it would be unfair to keep you out because you hadn't been notified of deportation when you left. If you come back to the airport next week, you can fly back to the UK. You can see out the deportation process. If that had happened, I dare say that I wouldn't get very far in a claim for judicial review attacking the original ATC refusal on Article 8 grounds or on some other basis, because the follow-on, the return hearing, as it were, would have remedied the unfairness. Equally, if the return hearing had resulted in a negative decision for the appellant, but had advanced adequate reasons, a complete answer to his complaint of unfairness, well then that too might have been an adequate resolution.
The problem that I've got is still, at the end of the day, he wanted to get back to the United Kingdom, and there had to be an addressing of that issue, and that could be in one of 2 ways. Yes, of course we should have let you back, or no way.
Yes.
You're not safe.
Yeah.
And that's what they decided in the exclusion decision or document.
Well, I'm going to come on to that in a
that's
moment,
not challenged
yes, it's not challenged, but
in these proceedings.
Can I come to that immediately then? So that was.
So we were coming, just to keep a note about this. We're at what stage of your argument?
We have just finished my 4th strand. of unfairness.
Yes.
I thought we'd finished your 5th.
No, I'm sorry.
When you'd started your 5th, I've written it down. Failure to reply to the 2nd.
No, that was all part of.
That was all part of 4.
All part of 4, which is if the decision, if the original ATC is such a fast-paced process that there's no time for adequate grappling, then okay, let's look at the follow-on. And the follow-on involves not just the first request for response, but also the second request for response.
Okay, so what's 5?
So 5 is, and this is subject to the question of whether I'm entitled to take the point in relation to the exclusion decision, the unfairness in my submission wasn't confronted by the decision maker when taking the exclusion decision. Now, if we might just take up the ministerial submission that the court received before lunch. At the bottom of page 6, page 6 is part of the main body of the ministerial submission. bottom of page 6, paragraph 9, records that on the 25th of September, unaware that he'd left the UK, foreign national offender returns served on Mr. Tasib the decision to deport. The decision was served by post. And then paragraph 10 overleaf, on the 28th of September, he sought to board. Now, there is no grappling there with the unfairness that was identified by Mr. Tasib, and which was inherent in refusing the ATC decision, knowing that he hadn't received notice of the deportation process. No grappling with that unfairness there.
But we haven't seen the submissions that were made, have we? Maybe that point wasn't made.
By Mr. Tasib.
Well, I think the position
Yes.
is that no submissions were made because the appellant hadn't managed to iron out legal aid to the exceptional case funding
Oh, I see.
scheme
Yes, I see. None at all.
and get the representation sorted out.
Yes,
I
see.
find that very difficult to understand on the facts, because I read this over the lunch hour, and a lot of the things that Mr. Tasib understandably would want to say about his niece, his sister, and so on, are all there. So I don't know.
Where's that come from? That's a perfectly fair question.
Yes, I don't know where that's come from. You
Well,
can't. I mean, the
I
Home
think it
Office
must have
would
come
have
from the
known.
judicial review. Because by this stage, the judicial review of the ATC is afoot.
And they refer to the judicial review. But in that case, in a sense, it doesn't really matter where it comes from, in the sense of what's the legal document.
Well,
They know what he wants to say, and he has said everything. He said everything about his sister, or they've seen the judicial review, and this is just a summary of what's said. And they did actually know, which I hadn't realised, that when they served it on him, he wasn't there. They knew that.
they knew that, but they didn't confront it.
Well, yes, they did. They said they knew it, but they still think he should go for other
Well,
reasons.
can I ask my lord to please look at page 13?
But anyway, he hasn't challenged it. Yeah.
Paragraph 8, this is one of the annexes accompanying the submission. Exclusion on the
Right,
basis of
which
serious criminality.
Which document are we now?
Sorry, it's the same set of pages.
Right, paragraph 8, page 13.
Page 13.
Yeah.
Sorry, I'm a bit behind in my reading of this. So, the actual submission runs from paras 1 to 22. Sorry.
Yes, that's right.
However, rather oddly,
That's an annex.
it includes an annex C, which is described in para 13 as a detailed consideration of
Yes.
exclusion.
Yes.
So you get the short version and the long
And the longer version. Anyway,
It includes other things. It includes the sensory remarks, the previous convictions, and C, although you say they weren't submissions, it says consideration of submissions of representations in relation. So it does sound.
it does say that.
Yes. And on the 20th, yes.
But the bit I wanted to draw attention to is at page 13, paragraph 8, which reads, exclusion on the basis of serious criminality is also appropriate in this case.
Sorry, it does look from 2, doesn't it? But although they were asking for all these long delays to get legal aid for experts, they did apparently on the 25th of April make some expert-free submissions. No, I don't know.
I know they don't say in paragraph 8, that he's left the UK brackets not knowing that he was subject to deportation, but that was mentioned. The minister would have read that in 9 before she got to.
Can I take this one point at a time, if I may? In response to my lord Sir Nicholas Underhill's point, page 12, paragraph 2, the last sentence.
Yes, no, I see
Instead
that.
of
I've read
providing
through
any
to the end.
substantive representation.
Yeah, well, that,
So that rather indicates there weren't any. In response to my Lord Justice Lewis's point, the point I wanted to pick up on is paragraph 8 on page 13. Exclusion on the basis of serious criminality is also appropriate as a factor in favour in this case because he's left the UK before it was possible to conclude the deportation process, meaning he couldn't be deported. That, in my submission, is a fundamentally unfair point to take against him.
Well, it depends how you read it. I'd read that because I'd read the previous paragraph when they knew it. What they're saying there is, fault or not, the fact of the matter is, he left and they couldn't conclude the process. Is your case that, well, of course, they would conclude it, because if they let him back, they could carry on with it? I mean,
What they're doing in paragraph 8 is counting against him the fact that he left the UK. They're treating it as his fault that the deportation process didn't conclude. But the whole point of what's recognised by the ATC decision maker on the date of the ATC decision is he was unaware that the process had started, and therefore he couldn't make an informed decision.
well, I'm sorry to say that should then have been a ground of challenge to the exclusion decision. This is the 15th of October. The hearing dates are said to be the 14th, 15th. It looks as if the Home Office provided this on the second day. But the problem is, if this is the point now, that they've treated him unfairly, because of course the only reason why they couldn't finish it was because they wouldn't let him back, not that he'd left. But whatever the rights and wrongs of it is easy, they just didn't, you just didn't take it. You didn't apply for an adjournment, or I just don't know the facts enough.
Well, my lord, if I may say so, that's a fair observation. And the court may conclude that strands 1 to 4 of the unfairness that I've identified are properly open to me, but strand 5 isn't, because it's not it's an attack on the exclusion reasoning rather than the ATC process. I've drawn attention to it. If the court disregards it because it doesn't properly fall within the challenge to the ATC decision, then so be it. Could I then please make the submissions that follow from the unfairness?
I'm sorry, forgive me. I was trying to link paragraph 8, which you took us to, with the guidance, which we haven't really been in, and trying to understand the left UK part. That this may or may not be helpful, but in your additional authorities bundle, the supplemental authorities bundle, paragraph page 107.
Yes.
We see a page which is headed grounds for exclusion.
Yes.
And that starts with the paragraph about when it's normally used. And then each of these are dealt with one by one, and we come to criminality, which is what is relevant here. In the second paragraph there, exclusion will not usually be necessary unless the level of criminality or the threat posed by the person is so serious that it warrants exclusion. For example, and it says what it says. And then it says exclusion may also be an option where FNO has left the UK before has been possible to conclude the deportation process. So I'm wondering whether the beginning of paragraph 8, as it were, is written by somebody who is well aware that this is the guidance.
Well, that does appear to be the case. I'm grateful for my lord identifying it. And it's that point which I say it was fundamentally unfair to take against the appellant, because of course he hadn't left the UK knowing of the deportation process. He hadn't left the UK for the purpose of avoiding the conclusion.
Well, he hasn't. He hasn't. It would have been possible to complete the deportation process without barring him from returning.
Well, there's that fundamental point, and then in addition, he was trying to get back for the purpose of engaging with the deportation process, because he changed his travel plans to come back 3 days after the stage 1 decision so that he could confront the deportation action.
I think what the Home Secretary's thinking is this: serious criminal, public interest should be deported. Why should we deport him? He shouldn't be in this country. He's left. He's not in this country. We don't have to bring him back, go through the rigmarole of deporting him again, and then sending him off. So all they're saying is fact neutral. You might say very unfair. You might say breathing a sigh of relief. We don't have to go through the effort. He's done it for us.
I don't accept
but
that
that's what they could be saying. Whether that's a nice thing to do or whether it's an odd thing to do.
I don't accept that's the right reading of
Of
paragraph 8.
That's paragraph 8.
I respectfully endorse the point made by my Lord Justice Jackson that when one looks at the guidance and when one looks at what's said at paragraph 8, it appears that the decision maker has in mind the leaving of the UK during deportation action as a positive reason for making an exclusion order.
It depends whether you mean read he has left us, he's trying to avoid deportation, or he's out of the jurisdiction, we can take a shortcut.
But what I'm relying on is it's also appropriate because. It's a positive factor in favour of an exclusion.
Right. Well, we're getting the gist of this.
The court has a point. And this is all subject to whether or not you're willing to entertain the fifth point. But
Yes.
Whatever the answer to that, I firmly place the first 4 points before the court as strands of unfairness.
And can I just be clear about this? These are all procedural unfairness given an Article 8 label.
Can I deal with that in a moment?
Okay.
I haven't. All I've done is identify unfairness. I now want to turn to the question of what does it mean in legal terms.
Yes.
Right.
So in my submission, 2 points follow. The first point is, what does this say to us in relation to issue 1? Now, in my submission, the scheme should be interpreted so that it's capable of operating fairly. And that's because, as a principle of interpretation, unless there's sufficient indication to the contrary, Parliament should be taken to have approved a scheme that was fair and not to have approved a scheme that was unfair. Now, we've heard that for good reasons, the decision-making process under the scheme is effectively automated with no real room for discretion when making the ATC decision. Essentially, it's baked into the scheme because of the timings that you just apply the paragraphs of the subparagraphs of 14. So although the scheme confers a discretion, there's liable to be little scope for the exercise of discretion in its initial application. So if you come within 14F, then authority to carry will almost certainly be refused. Now, in my submission, that makes it particularly important to consider whether the rival interpretations of paragraph 14F, as between the appellant and the respondent, render the scheme capable of operating fairly in all or nearly all cases. Now, if the scheme is interpreted in the way that I've submitted, then 14F will always operate fairly. Because everyone caught by paragraph F will have had fair warning of the deportation process. And just as with deemed abandonment of an appeal under section 92, subsection 8 of the 2002 Act, if you go abroad, your appeal is treated as abandoned. Just as with that, one takes the consequences of leaving during the deportation process.
But category 3 doesn't require notice. It could just be as unfair.
Category 3 in my submission absolutely does require notice for the Anafrieva point. On a proper interpretation, category 3 requires that the process has started before the individual leaves the UK. That's just the language of category 3. And in light of Anafrieva, that has to be interpreted as meaning the person has been told that the deportation proceedings have started.
But on the Secretary of State's interpretation of Category 2, it will only be in the rarest case of effectively bad luck. We maybe that the process will have started without the other party being, without the potential deportee being aware of it.
Well, we don't know.
Because in the huge majority of cases they will have been told in prison. Even if they haven't been told in prison, it will be very unlikely that they go abroad just while the deportation notice is in the post.
My lord, I accept that it's unlikely, but in my submission it will be a legally significant class.
Well, you said, I think rightly reflecting the case law, it shall be capable of being operated fairly in the great majority of cases.
Well, looking at the flip side, shouldn't result in unfairness in a legally significant class of cases. Now, to pick up the point that my lord made in response to my opening submissions, one can contemplate quite readily situations in which a person may not be served with deportation proceedings while still in prison. My lord posited the example of somebody who's served a long period on remand.
Well, yes, but then they'll be served after they come out of prison.
Well,
but what occasion? The only thing really that the operative failure in this case was simply the fact that he went abroad at a time when the notice was about to be sent.
yes, but there will undoubtedly, in my submission, be other such cases. Now, how large that class is, I can't say, but there will be other cases. And my submission is that my interpretation of paragraph F of the scheme strikes a fair balance. It ensures that everybody who's subject to paragraph F is treated fairly. It also ensures that the paragraph is effective from the Secretary of State's point of view, because from the moment that a person is notified of deportation proceedings, if they choose to leave, they're caught by paragraph F.
Right. Okay, so you deploy it in relation to issue 1.
I deploy it in relation to issue 1, or just to finish that point, if the scheme is interpreted in the way that the Secretary of State submits, then it will necessarily operate unfairly in some cases, of which this case is an example. Right. And so fairness, we say, is an important guide to the interpretation of the scheme. Right. That's the first point. Second point, then, is the case-specific legal consequences. So if the scheme isn't interpreted in that way, so that it bakes in the possibility of unfairness in a case like ours, then the unfairness to the appellant rendered this particular ATC decision unfair, and that has, in my submission, 4 potential consequences legally. Consequence 1, it rendered the ATC decision unlawful as a matter of public law. Now, if one wants to give that a public law label, it was either straightforwardly unfair in conventional terms, or if one's dealing with substantive unfairness, the failure to grapple with and justify the substantive unfairness was unreasonable.
I mean, substantive unfairness has been said a number of times not to give rise to a public law error.
Well, that's why I put it in the way. That's exactly why I just put it in the way that I have.
So unlawful as a matter of public law because the failure to consider the issues.
If one is dealing with substantive unfairness, it is the failure to grapple with and justify the substantive unfairness that is unreasonable. And so if one's giving it a public law label, it would be unreasonableness.
Now, which ground of appeal is this?
Well, and I accept the difficulties that I accepted in my opening submissions. The best I can say is that this is broadly what ground 3 capital A of the judicial review was driving at, but I cannot say that that was pleaded with any degree of clarity. Consequence 2, that breach of domestic public law meant that the decision wasn't in accordance with the law for the
And by decision, do you mean the specific decision on the 28th or the ATC process?
The ATC process.
Yeah.
So that breach from the process of domestic public law, we say meant that the decision wasn't in accordance with the law for the purposes of Article 8.2. It's well established.
Yeah, okay, yeah.
I don't need to trouble my lord with that. Consequence 3, it would be liable to constitute a breach of the procedural aspect of Article 8. And consequence 4, substantive unfairness is an important factor in the balance for the purposes of Bank Mellet Lim 4 of the proportionality assessment on the substantive aspect of Article 8. So those are my submissions on the nature of the unfairness and the legal consequences.
And just to finish that off, if it's Schwidler and we do the whole thing again, I can understand how you can get those in. If it's not Schwidler and we're reviewing, were these points put to the judge below? Because she can't have made an error if they weren't.
No, I accept that.
Yeah.
Can I turn then? That's all I wanted to say about fairness and consequences. Can I then deal with issue 2, Article 8 specifically, and begin by addressing my Lord's question about what if this isn't a case where the court should say, well, it's the first time the appellate courts have considered the ATC scheme, so regardless of error in Mrs. Justice Farby's analysis, we're just going to conduct a proportionality exercise for ourselves. If the court rejects that approach, what do we say are the flaws in Mrs. Justice Farby's analysis? Well, in my submission, she doesn't confront the unfairness to the appellant as part of her Article 8 analysis, and fairness to the appellant had been squarely put.
Sorry, fairness to the appellant had been. Just didn't hear.
Squarely put.
Where? Which ground? Is this 3A again? Because common law unfairness had been rejected, had not been given, was not before her, was it? So that's why I just wondered how fairness came in.
I can't say how things were put orally, but in terms of, the court has got the flavour of my submissions on the proper interpretation of the scheme, in which fairness is featured large. When one is making submissions about what happened to the appellant, it's rather difficult to avoid.
Well, I see that, but nevertheless, there had got to be an articulated fairness challenge. And when one says the judge didn't confront it, one does want to know how it was put to her, and we can see how she thought it was put to her, because it's a meticulous judgment that says these are the submissions and these are how I deal with them. And unless you can show me her reciting a fairness submission and then not dealing with it, you've then got to show me something in the pleading. And I thought your answer, which I do understand, but you acknowledge it's not straightforward, is, well, it should be brought within ground 3A.
Well, that's part of my answer. But if one looks at the summary of the claimant submissions at page 104, paragraph 130 and 131, there are certainly strands of unfairness in those submissions.
So hold on, 104?
104, paragraphs 130 and 131.
Oh, we'll be back in the journal so I can take it out.
Sorry.
But if we look at 130, 3 ways separated, that's substantive unfairness. Then 131, secondly, puts at risk the merits of his FTT appeal.
Yeah.
Thirdly, perhaps this is it then, Mr. Halim submitted the adjunct breach the procedural element. No, that's a different point. That's the point. That's a point about how he won't be able to manage his out-of-country appeal.
Yes, I mean, if one goes back to page 82, paragraph 8 on page 82. The ATC decision has caused him to be located out of the UK.
So sorry, 84.
Page 82, paragraph 8.
2.
I really think it should be so easy to point to the paragraph in the pleadings, and if that failed, the paragraph in the skeleton argument, which made it clear that there were 4 or 5 elements of unfairness as a result of which there was a breach of the procedural obligation in Article 8.2. I'd expect to see reference to the authority giving rise to procedural rights, because you don't usually think of Article 8 and procedural rights, although I know they're there. So it's a bit of a stretch. I know it's my fault because I raised it yesterday, but I wonder whether I should have now. Being honest. I thought it was in 3 because I thought you could cross out historic injustice and ignore that, but Mr. Dunlop says I can't do that.
Well, in my submission, the whole case is infused with the question of fairness, and there are strands of unfairness that have been drawn to the judge's attention. They haven't, at least as recorded in the judgment in the skeleton argument, been put in the way they've been developed as fully in this court. The other...
Your fallback position is to say, well, we can do the proportionality exercise straight because of its importance on the Schwindel.
Exactly.
But even then, I'm not sure that points not taken below.
Oh, well, I respectfully disagree with that.
You don't, well, because it's Article 8, everything comes in.
Yeah, we've got to do it ourselves, you say there.
Yeah, all right.
Yeah, I'm afraid I would firmly push back.
No, all right. I see how you would put that.
The next element, and whether it's properly a criticism of the judge below or whether it's really a matter for this court to consider for itself, is that the judge, and it may be a consequence of how the case is put, doesn't confront the point that the public interest in deporting a foreign criminal is secured by the deportation process. The question, should the deportation process, including any in-country right of appeal, be short-circuited? Does the public interest require that short-circuiting? Why not let the appellant back to avail himself of the procedural benefits of making representations and of a potential in-country right of appeal? Well, that important question isn't addressed in the judge's analysis.
But we know why she...
Well, what the judge does is she identifies the public interest in deportation. And she does that squarely by reference to the sentencing judge's remarks. But in my submission, that misses the mark, because that's not the question before the court. And that, I think that criticism is properly open to me, because the judge herself recognised that the target of the claim is the ATC decision. And there is a mismatch between recognising that one is considering the Article 8 proportionality of the ATC decision, but then looking at the proportionality of deportation as an answer to that.
Yes.
The judge, I note also, and I think this probably is because the point may have not been put in that way, doesn't address the significance of the appellant having ILR and what that indicates about his rights to be in the UK. And I think this wasn't put, but if the court is going to re-examine matters, she doesn't address the fact that the Secretary of State declined to detain or bail the appellant in the period February to September 2024. One point I need to draw to the court's attention in relation to the Article 8 balance is that I said in my opening submissions that the appellant had never met his daughter. In fact, he met her in April 2026 when she and her mother flew out to see him.
Thank you.
I'm not sure that changes any of the analysis, but just so that I haven't misled the court. Is the Article 8 issue going to be adequately addressed in the first-tier tribunal? There's still, even if it were going to be, we are still concerned with a 9-month period from ATC to exclusion decision. Even if one stops at the invitation to make representation stage, we're still talking about a 4-month period. The Secretary of State has said that she reserves her right to appeal from the tribunal decision on a jurisdictional basis. On any view, the appellant has lost the right he would have had to an in-country appeal with all of the advantages that entails. And even if the appeal could fairly be heard from abroad, his Article 8 claim has been damaged from the date of the ATC decision until the eventual date of the tribunal hearing. On Article 8 impacts, yes, the wife chose to stay with him following the ATC decision, but that was itself a significant...
Sorry, just... yes, I mean, we're just thinking to keep you within the bounds of reply. I mean, I think Mr. Dunlop did, in passing, mention this, but it's not really a core...
Not a core reply. Very well.
A core reply issue.
Certainly. I'll try and keep to the
right.
most significant points. Can I deal with the question of whether it matters what the Secretary of State knew? In my submission, the answer to that is misbehaving in the House of Lords. It's what the House of Lords holds in that case is the process of reasoning by the public authority is irrelevant to the question of convention compliance, save, or rather, an absence of public authority.
Is that quite the same thing? I'm very familiar with that, which cuts both ways. You've just got to... But where you're dealing with a particular administrative decision, it's got to be taken in the light of the facts as they were.
Well, I accept that. I think I accepted that in my opening submissions.
In practice overlaps so much what they were known to be.
Well, whether the Secretary of State knew is, in my submission, irrelevant. What matters is that the facts existed at the time. All were reasonably foreseeable at the time.
And were knowable.
Were knowable.
To the Secretary of State.
Exactly, if inquiries had been made or whatever.
Right.
Yeah. So that's all I wanted to say in response to that. I don't know whether the court wants to hear from me on Article 8 jurisdiction. I have an answer to the supposed tension between the authorities, but it may be that
beyond what you told us at the beginning.
Well, I was just going to show my lords how it was put in the authorities on which my learned friend relies. I mean, if that's potentially some assistance, we'll turn please to tab 34.
No, we'll hear what you say about that.
Tab 34. Now, this is a SIAC decision, but it's one that's of a piece with R3.
E5.
C5, so the piece with R3 is the same situation where there's a deprivation of citizenship case, and SIAC explains why.
So which page, sorry?
Begins at page 695, and the bit I'm interested in is page 705.
Yeah.
And one gets the best explanation of why it is that a deprivation of citizenship case doesn't come within jurisdiction. And if I could draw attention to paragraphs 55, 58A, and 59.
Yes.
And so the punchline is 58A, that the deprivation decision doesn't prevent the person from coming to the UK. By contrast, in our case, the ATC decision squarely prevents the appellant from coming to the UK, or prevented the appellant from coming to the UK. Now, the Secretary of State accepts that an entry clearance application engages Article 8, but the appellant doesn't need to make, didn't in this case need to make an entry clearance application because he had ILR. And in my submission, it would be absurd for an entry clearance application to engage Article 8, but a refusal of permission to travel not to do so. That's a jurisdictional point. Finally, if I may, issue 4.
Just to remind me, what was issue 4?
Issue 4 is the
Commonwealth, yes.
Yeah. So, what's the nature of an exclusion order? The guidance that the court was shown by my learned friend indicates that in substance, it's a deportation order for someone who's left the UK. That's the flavour of it. Now, at least up to 1971, this was a prerogative power. That's the effect of, well, and then the effect of G1 is that post the 1971 Act, that prerogative power remained available, at least in relation to aliens, because of course G1 was an alien case, and we say that G1 is binding for that proposition. The effect of Munir and section 35 subsection 3 of the 1971 Act and section 51 subsection 4 of the British Nationality Act is that the prerogative power, so far as it existed, was extinguished for Commonwealth citizens. Now, the Secretary of State's submission is that the exclusion power for Commonwealth citizens is now governed by the 1971 Act. The problem with that submission is that if the 1971 Act gives full statutory power to make exclusion decisions, then the prerogative power to make exclusion decisions must have been abrogated for all purposes. It must have been abrogated in 1971 for aliens as much as for Commonwealth citizens. It wouldn't be section 35(3) that's doing the abrogating. It would be the replacement power that would be doing the abrogating. The problem with that is that is contrary to the ratio of G1. Both things can't both be true. The 1971 Act can't have abrogated the prerogative power in relation to the power to exclude for everybody, and G1 be rightly decided. Of course, in my submission, bound by G1. Can I then give a more granular response on the 1971 Act, which is that it's common ground that an exclusion decision purports to instruct entry clearance officers. The question that's come into focus, is whether paragraph 1, subparagraph 3 of Schedule 2 contains an implied power to instruct entry clearance officers. Now, the difficulty with the implied power argument is that when the Immigration Act was enacted in 1971, there was no need for the Secretary of State to instruct entry.
But hang on, I didn't understand the submission to be as an implied power, nor that's what Ms. Simler, as she then was, said. She said it's in the general powers in Section 1.
Yes, but
Well, the Secretary of State's got to be able to rely on an instruction power in order to instruct entry clearance officers. My learned friend Mr. Dunlop pointed the court to paragraph 1, subparagraph 3 of Schedule 2.
Yes, but that allows the Secretary of State
To instruct immigration officers.
exactly, but the power to give this particular instruction is part of her powers conferred by Section 1, or is it Section 3? I forget which.
That would be, in my submission, a surprising conclusion. Where Parliament...
Well, isn't it what Ms. Simler said?
No, she's not dealing with entry clearance officers at all. She is dealing with immigration officers. And she's right about immigration officers.
Oh, I see.
She's right as far as...
All right, this is a point specifically about entry clearance.
This is specifically about entry clearance officers.
But, well, right, but then the answer to that... all right, I was misunderstanding your point. Carry on.
so does it contain an implied power to instruct the ECO? And you said when enacted in 1971.
When enacted in 1971, there was no need to instruct ECOs. Because, as Mr. Dunlop explained, in 1971, a grant of entry clearance didn't operate as a grant of leave.
And you can't have an implied power unless it could be used at a particular point. Why can't be an implied power give instructions to immigration officers or others where relevant?
So so in 1971 there was
or ancillary.
I'm going to deal with that. In 1971 there was no need for the Secretary of State to be able to instruct entry clearance officers. It was enough that she could instruct immigration officers because the immigration officers could refuse leave at border. That then changed by virtue of the 2000 order, which gave the effect of entry clearance as a grant of leave. But the meaning of paragraph 1, subparagraph 3 of Schedule 2 couldn't, by some metaphysical process, change when the powers of ECOs were expanded. In other words, the 2000 order couldn't change the meaning of paragraph 1, subparagraph 3 of the 1971 Act. And that also, in my submission, militates against there being an ancillary power, because Parliament has seen fit to give an express power for the instruction of relevant officials and limited itself to immigration officers. So then, just on Kakani, there's no... the Deputy Judge didn't address the GI points. It doesn't confront the prerogative power points. And, as I've already indicated, the Judge didn't need to and didn't address the entry clearance points. Paragraphs 47 and 54 of Kakani only deal with immigration officers. Now, I make one final point on this, is that if one were to do what my Lord Justice Lewis posited in argument, and if one were to read immigration officer as embracing entry clearance officer, then one would be radically increasing the powers of entry clearance officers. because then they could exercise all powers of immigration officers. Unless the court has any questions, those are my submissions in reply.
My lord, sorry to interrupt. There's one thing I thought I should draw to your attention that assists my learned friend.
Yes.
Would you like me to do it orally or consult my learned friend and send you an email?
I'm sure if you say it assists him, he'll take it at face value. So tell us what it is.
Yes, so my learned friend replied to a point I hadn't made, which was he suggested that or I was making an argument that category 2 of paragraph F would be completely worthless, and if his interpretation was right. And I didn't go so far as to say that. And so he focused on that sort of scintilla of time between the junior caseworker making a decision and the director signing off. That's all focused on automatic deportation. I thought I should draw to your attention that in a conducive deportation case, that's to say one where it's not a foreign criminal, there will often be a period of time between the stage 2 decision, if it addresses a human rights claim, and the deportation order. That's because there is a statutory bar on the deportation order in such a case until the appeal rights are exhausted, and that's section 79, page 57 of the authorities bundle.
Thank you very much. Thank you again. We'll take time to consider and let you have our judgments in due course. Could you please help us with any obvious errors or typing mistakes? Agree a draft order reflecting, or if we're left at a point where in reality we're looking for submissions on consequences of the decision, take it as far as you can and make submissions about what should then follow. We'll let you know then what our views are in relation to publication of judgment and how matters will proceed from then on. It's the sort of case in which we hope that we'll be able to deal with all of those matters on paper. If it doesn't prove possible to do that, then we'll have to think about what to do next. But
Thank you. I'm so sorry, my lord. Could I just...
yes, certainly. Anything else?
I'm so sorry, my lord.
Nothing else? No. Thank you all.
All right, in favor?